Ms. Smith, you may proceed.
Thank you, Your Honor. I'm going to go in a little bit different of an order because I think the first issue is, did the police lawfully seize the phone from Mr. Montgomery? It was a phone in his possession. It was a phone he indicated he was using. He was ordered to give it up, and the police had no warrant. So, what probable cause did the police have to seize the phone? And we heard from Detective Dunleavy about why he took the phone, and it was in the morning he said he had no phone, and that afternoon he now has a phone. Kelsey said the phone was Adam's. However, you learn that that was afterwards, not at the time he seized the phone. And the interaction with Kayla was prohibited by the court. Again, afterwards he learned it. And Kayla wrote that it was her phone again after. So, he took the phone essentially on a hunch. That Adam said he didn't have a phone in the morning, and then there he was with a phone in the afternoon. That's a hunch. He did not say anything about probable cause to believe at the time that he took the phone that it had evidence relevant to the investigation into Harmony. He didn't say anything about that at all. So, by his own testimony, he took the phone because in the morning Adam said he didn't have a phone, and there he was with a phone in the afternoon. Adam possessed the phone. It was seized from him unlawfully without a warrant. And so it should stop there. And everything that flowed from that unlawful seizure should end the conversation. In the event that it does not, the second question, I think, is exigency. I think exigency actually goes along with the probable cause, in that if they don't have probable cause to seize, exigency doesn't exist with a hunch. So you can't just say, hey, this might have something, let's take it now and see. Let's figure it out later. The thought that there was probable cause to believe the phone had information about Harmony's whereabouts actually is right on point with your question. If the phone was seized because it might have information on Harmony's whereabouts, then the phone gets searched right away. You heard the detectives in the interview with Adam, concerned. Please, please tell us, we must find. There was no connection from this phone to Harmony's whereabouts or the investigation into where Harmony was. If so, they would have searched the phone right away. So when they seized it, there was no probable cause. Perhaps information later may have gotten there, but at the time that they seized it, they did not have probable cause. And as I put into my motion, there's no evidence other than it just seemed like a good idea. That is a hunch and does not justify the seizure. And again, I mess everything up. Thought I had it right there. Where's my heart? Okay. Thought I had it. There it is. So, then the next question I think is standing. And the state said that they have cases from all over the country. And they cited 3. And of course, I looked at the 3, and the 3 actually rather support our standing. So remember that when the phone was removed from Mr. Montgomery's pocket and it was put on the sidewalk when it was seized, that was pointed out to you in a video. And then there was another video where he was permitted to retrieve his possessions, which included the phone. and he took his possessions, which included the phone. Then asked if he had a phone, he pulled it out, and when the phone was being taken at some point after I think that they asked about the battery going out, he said that it wasn't his, but it was the phone that he was using. And then you saw that when the officer walked away, a couple of minutes later, Mr. Montgomery was looking for him, asking, what's the matter with Mr. Montgomery? Well, he took the phone. So yes, he was not only having a possessory interest, he had a controlling interest, and he showed his interest in the phone. It was clear that he was looking to have it returned when he was looking for the officer who walked away. So, the cases cited by the state. United States versus Lindsay absolutely stands for the proposition that there is no standing when a defendant does not own, possess, control the cell phone for any length of time other than immediately before the police seized it. Mr. Montgomery possessed it, he controlled it, and there's no information other than it was the phone that he was using, that he only got it immediately before the police seized it from him. The evidence is otherwise. But in Lindsay, factually, what happened was that when the police came in and they found the phone, they asked Mr. Lindsay, what cell phone are you using? At some point, Lindsay says that cell phone that they had seized belonged to his sister, and he was just keeping it from the kids because they were playing with it, and that it was locked. He completely got rid of any interest in that phone by saying not only was it his sister's, but that he wasn't using it. He was just holding physically onto the phone to keep the kids away from it. The court in Lindsay noted that he failed to produce any evidence showing that he owned, possessed, used, or controlled the phone in issue. Here you have plenty of information that he possessed it, he said he used it, and he controlled it prior to the police taking it away from him. It was on his possession before they stopped him. What's also interesting in Lindsay is that when they did search the phone, they searched it for a very specific time period. It was a month-long period, I think. But it's interesting in Lindsay that you can limit a search of a phone to a time period. In Christensen versus City of Boone, it was cited for the premise that the defendant officer had no legitimate expectation of privacy in a cell phone belonging to someone else. It did not only belong to someone else, but it was in that someone else's possession, and there was no indication that Christensen had used it. What happened was a sheriff went to a friend of, I got confused about who was the petitioner and who was the defendant, but a defendant police officer has communication with his friend. They go to the friend and want to search the friend's cell phone to confirm that communication with the defendant police officer. So, absolutely not. The defendant had no possessory interest, he had no ownership interest, he had no information on, he had never used that phone. That phone he did not have an interest in, so he did not have standing to object to the search of the phone. Then there was United States versus Curry, standing for the proposition that disclaiming ownership, which is kind of similar to Lindsay, who disclaimed ownership, disclaiming ownership of a cell phone prior to its search relinquishes any reasonable expectation of personal privacy with regard to it at the time of the search. Once you read Curry, you will also see that the court looking at it, and what in Curry the defendant said, the defendant was sort of tackled outside of Walmart, and a phone came out of his pocket, and the phone was halfway out, so they picked up the phone, and they actually searched it prior to him talking about it, but at some point they're in the presence of the defendant later, and he says, "It's not my phone, it was on the ground at Walmart," essentially saying he had just picked it up, had no interest in it whatsoever. Interestingly, this Curry court found that the defendant did have standing. He did have standing because it appeared that he had the possessory interest at the time that they took the phone and searched it illegally.
But isn't that different than here? Because here, they didn't actually get the search warrant to search the content of the phone until they had identified at least some evidence that the ownership was with Kayla Montgomery.
Absolutely, but at the time that it was seized, it was illegally seized. Let me rearrange my thoughts there because I just leaped way ahead. It is different in that he had standing because he disclaimed the phone later. I agree. But the issue is that the disclaimer in and of itself does not get rid of standing. It is circumstances, that's what I was getting to, the totality of the circumstances surrounding it, and the timing. And here, Mr. Montgomery said he not only possessed the phone, but he said he was using the phone and he was showing that interest in getting the phone back. It's a very different story. In Curry, they cited Dow. So it's in the case, but the site was 786 F sup, at 1073, 1991 case, that talks about, for the proposition that in a disclaimer context, the issue is whether the defendant has voluntarily discarded, left behind, or otherwise relinquished his interest in the property. He did not do that. He didn't voluntarily discard it. It was taken from him. He didn't voluntarily leave it behind. It was taken from him. He didn't relinquish his interest in the property. He was looking to get it back. And so that's what you look out to see if somebody retains a reasonable expectation in privacy of the item relinquished. So then those cases essentially rely on Rakes versus Illinois. And because they were in the cases, I think I didn't hold on to the site, but I can get it when my argument is done, which involves a discussion about having no standing. And in Rakes that they relied on, it was passengers in a car driven by the owner, and they tried to say that they were legitimately in the car, therefore since they were legitimately there, they had an expectation of privacy in particular areas of the car. And they said, no, in this case, even though they're legitimately there, they have not asserted any expectation of privacy in this. Mr. Montgomery asserted use of the phone that contained his information that the police were going to search. He had a controlling interest in the phone. He was using it. He had a privacy interest in the contents. And one of the things that it's not really analogous, but as we look at United States versus Katz, which was actually the telephone booth case, where Supreme Court case 389 U.S. 347, where the police had put a surveillance on a phone booth because the defendant had been observed many times going to the phone to make illegal communications, to make illegal arrangements. And the state tried to argue that this was a public place where the defendant was using the phone, so he did not have that privacy interest in the content. It didn't matter. It was the phone that he was using, so the content of his use, which was actually the conversation in that point, was protected by the Fourth Amendment, and they didn't address standing, the fact that it was a public phone and not his did not take away his ability to object to the surveillance search. So, now, I think I've already talked about exigent circumstances as articulated by Detective Dunleavy. But I will mention on the state's objection that they mention that there's a missing 7-year-old girl. Adam is the custodial parent. There's a fair inference that evidence of a child will be found on the custodial parent's phone. A, that's a hunch. It doesn't rise to the level of probable cause. But B, we also have different information about this phone, that it was not his, it was a phone that he was using. So is there a fair inference that it has information from the time of Harmony's disappearance? Exigency and probable cause did not exist at the time that the phone was taken. So then the next step is, in the analysis of probable cause, you asked about State versus Stacy and that delay. And, Your Honor, again, that delay shows that there was no probable cause to believe that there was information about Harmony's whereabouts on the phone, because they daggone well would have gone exactly there to try and find it. Actually, the delay here not only reaches constitutional proportions, but it's actually evidence that there was not probable cause. The delay here is also very telling as it goes to probable cause to believe that there was a violation of a no contact order, because when the state objected, they said the delay was not unreasonable because the warrant was sought 3 days after it was learned that it might be Kayla's. That would have been, I believe, the 27th. So that was still 28 days later that they get information that the phone might be Kayla's. Hey, let's search it. That is evidence that there was not probable cause at the time that they seized it. Stacy, and I urge you to read it as well, is very, very clear. In Stacy, the officer seized the car, I think, and it was right before a holiday weekend or something like that, and he was quite diligent, and I think there was a delay of 4 days, and they found the delay not unconstitutional. So then we get to the scope of the warrant and whether or not that there was probable cause for the scope of the warrant. So I'm going to point out several things here. First, in the first page of it, it says in the probable cause statement to search form that there's probable cause to believe it contains the crime of indirect criminal contempt. The judge found probable cause to believe that the crime of indirect criminal contempt was committed. The judge did not find any probable cause with regard to any of the investigation into Harmony. The device was a blue phone believed to be Kayla's, and the attachment A in the affidavit on number 3, the introduction and background, paragraph 3 is, the affidavit does not contain every fact known to me, rather it contains material information relevant to determining whether there is sufficient probable cause to believe that the crime of indirect criminal contempt has been committed, and whether evidence of that crime will be found on the device to be examined. I will also say that in that introduction part, The officer does not give any expertise in forensic examination of a phone or any of that sort.
Let me just ask you, Attorney Smith, I've made no decisions, obviously, but in the event that you get over the standing and I find there was exigency and I'm looking at the probable cause, it sounds that what you're really arguing is the breadth of it, not that perhaps that it couldn't be searched from that December 27th through the December 31st timeframe for that. Well, no one tells me what was on the phone, and in some ways it doesn't matter, except to the extent that if I get to this point and I say, okay, I think there was probable cause to search some of the phone, what is it that you're trying to exclude? Like, was there information that was found outside of that time frame? I don't think, no one gives me any information about that at all.
Yes. And so there was information about communication with Kayla outside that time frame, but the police also have all the contents, and I've got to tell you, I've had a miserable job getting access to it, but that I know that there was information outside that time period from a police report. Mr. Gorecki, who was here earlier, has also been tasked with trying to assist me to find out all the other stuff, but I know that evidence exists outside that time frame. So everything outside that time frame.
Okay.
So, okay.
I mean, if that's, yeah, I guess, and then the other question is any of this relevant to the gun charges that are going forward in November?
Again, I'm not sure because I have not had that opportunity to study it so much to see. The only information that I have is the communication outside that time period.
I mean, I guess, I don't want to do this. This is not supposed to be an exercise. I'm supposed to be excluding, something.
Yeah.
And so, for example, if there isn't anything related to the gun charges, and we're, looking at the next case, which is not yet scheduled, I guess I would like to know that. So you do not know what the contents was?
I don't have access to all of it. I'm asking Mr. Gorecki, but I know that there is material outside the time frame. It applies to contact with Kayla. It may apply to the charges of endangering or interference with custody, rather. And when we discussed the motions that we had to file, it sort of came out that the motions to suppress were applying to both cases because the state had not taken any decision about what would apply where. No delineation of this is all the evidence only with this. They would not commit that there was not evidence in the Harmony case that they would not use in the armed robbery case.
Okay.
So it's not simply an exercise, but it may be an exercise just for the Harmony case because I don't have all the content. Do you know if it contains anything for the robbery?
So directly, I would say, to the best of my recollection, direct evidence, admissions about the robbery or pictures of the robbery or anything, those are not there. There is, though, potentially, depending on witnesses that may get called at the trial for the firearms charges, there could potentially be either evidence that the state might use to impeach if they're defense witnesses or evidence that might be relevant to their testimony. But in terms of direct evidence of the firearms case, I don't believe that's on the phone in question here.
Okay. But you do think that there's evidence on there potentially to be used in that case?
Yes, Your Honor. With regards to, again, possible examination of witnesses, or if defense would choose to do that, to cross-examine potentially some of the state's witnesses. So whether it goes to credibility or not, there is a possibility there.
Okay, thank you. All right, I just want to make sure that this is not just an exercise.
No, I brought it because they
Okay.
did obtain stuff
Okay.
outside of that range.
Okay, go ahead. You were saying that there was no expertise.
Oh, in
and then-
his,
and-
okay, thank you.
Okay.
Um,
And that there was, then I asked you about was there communication outside the time frame, and you said yes, so.
Okay. So then, looking at probable cause for the phone. One of the claims within the affidavit was that there was a court order that the two, Kayla and Adam, could not have contact, but there was an order that also, but the order also included that except as provided by the DCYF case, and then it goes on to say the DCYF case was closed. It does not indicate that the DCYF order did not authorize communication between the parties. So I do not think that they had probable cause to believe that there was an order in place prohibiting communication. You actually saw a discussion of that by Adam, but that's not in the affidavit. But what I am saying is that they recognized there was a caveat to the order, but they didn't go to see what they tried, but the case was closed. They would have to take the extra step to see what the DCYF order was to determine if contact was authorized in certain circumstances by the DCYF order. The second thing I have to say about the affidavit on the facts is, I think paragraph 22 and a portion of 22 and 23 has to be stricken, and 24, although there's some information of when Crystal had or did not have contact with Harmony, the comparison to what Adam claimed needs to be stricken as it was from the previously suppressed 12/31/21 conversation with Detective Dunleavy.
I mean, the fact that they agreed that they recently agreed that would be suppressed.
You've granted the motion to suppress.
Right, I understand, but does that mean that I excise that out of an affidavit?
Under State versus Gravel, illegally obtained evidence can't be used to sustain probable cause for a warrant.
Your Honor, I believe it's a matter just of terminology. I believe what Attorney Smith is just trying to argue is that it needs to be disregarded,
Okay.
not necessarily that it needs to be stricken.
Thank you.
So you look to see if there's probable cause with that redacted or discarded or, yes.
Right, thank you.
Not considered.
Go ahead.
Also with the probable cause affidavit, it describes known contact between Kayla reaching out to Adam Montgomery in Maine. And the phone used was a landline phone that was switched to another relative's phone, another relative of his girlfriend, in Maine. No reference to Adam using a phone at all. The contact that was observed, according to the affidavit, was that Kayla was seen talking to Adam on that day by two different police officers. outside of her residence. Again, no indication that a cell phone was used to set up that meeting, and quite the contrary. Adam had walked from the police, where they stopped him at Union and Lake, and walked over to Families in Transition and had the contact with Kayla that is referenced in one of the paragraphs. So you can't assume that a phone was used to set up the contact. If he knows where she lives, he goes over to where she lives, as he did, because they had the phone then. And he just walked over. So I think all of those affect the actual probable cause. The subsequent interviews that are discussed, not the interviews, I'm sorry, the subsequent evidence that they learned that Kayla, had on the 27th, they got information that the last phone that she had before the cops took it was, and I will just, the cheapest in Walmart and of the same ilk as the phone that was seized from Adam. It does not say that it's hers. Then there is the day after that there's surveillance video of the three of them, Adam, Kayla, and Kelsey, walking into Walmart. And they can positively identify them, and after entering, Kelsey and Adam separate. This is kind of important for a different reason, but I wanted to point that out before I went too far from the scope. So, now we have a request for a search. And in that request for a search, on paragraph 40, the affiant acknowledges the relevant time period is 12/27 through 12/31, and that's the time period that they want to determine if the two had communication over the phone. But as this bald assertion that deleted items may not have the correct times or dates, or can be edited, other items I guess can be edited, they want all the information on the phone, completely all of it, whether inside the time period or outside the time period, and whether having anything to do with communication between Kayla and Adam, which is the purported reason that this warrant was granted. And how is it outside the scope? Because they've asked for probable cause to find that the phone may contain contact between the two during the relevant time period, and yet they asked for all the storage files, user attribution evidence, indicia of occupancy, indication of who has used or controlled the device. To find out indication if Kayla or Adam used or controlled the device is one thing. To get everything else about that device based on the probable cause as articulated and found by the judge, no, it's beyond the scope. They want to get everything to draw conclusions about how the devices were used and the purpose of their use and who used them. No, you've got probable cause about communication between Kayla and Adam during this time period. It doesn't open up communication with everybody else and how it's being used and what it's being used for. Identifying exactly how information is stored is a dynamic process. That's C under that. And this is what has to be pointed out on C. Whether data stored on a computer as evidence may depend on information stored on the computer and the application of how the computer behaves. This is a template. This is not a computer that's involved at all. It's a cell phone. This shows that it's a template, not specific or particular to this case or the probable cause articulated. It's a template to get into every item that possibly can be gotten into. And then there's probable cause to believe the following data device will be evidence of crimes under investigation. The only crime under investigation that they said there was probable cause for that they were seeking was indirect criminal contempt. And I will again say what is articulated about Harmony, although the state said we can check any crime, there is no probable cause to go beyond what they have articulated they need for the investigation into contact between Harmony and Adam. But they want contact lists, address book, calendar, schedule, date books. That's beyond whether or not Adam or Kayla had contact. Text message history,
So
all of that
I'm concerned
within the
about
time
time.
period.
I'm concerned about the time, and
Yep.
I get the gist of your argument, and I understand that the court would need to go through each of these things. I don't want you to have to go through each of them. If you think I kept the staff very late yesterday, so I need to be cognizant of not doing that again today. So if you feel that this is gonna be, if you have a lot more to do, then we're gonna need to come back. So I just wanna, I don't wanna cut you off, but if you have a significant amount left, then we should talk about whether we're going to finish today.
I think one of the things that I pointed out and asked you to take note of was while conducting the investigation, there was no contact order except as permitted by the family court. Again, there is no family court order in there to say what the contact was. So the final issue, I guess, is privacy, that under Riley, the content of the phone is what is covered in the privacy interest. It is not merely the possession of the object, and I think I've cited Riley throughout to make that absolutely clear. But the other is the New Hampshire Constitution, that the amendment that was passed, and I believe it was in 2018. It was, by the way, right around the Page decision. It was not addressed in Page. And the other thing that I've said about Page is Page does not open the floodgates to you can go everywhere in the phone just by saying you need to. In Page, it was about the photographs, and unlike other stuff in the phone is connected to the cell tower. There is, that data is very different from photographs. And in Page, they talked about photographs. You have to go through them all to find out if they're evidence or not. And they can be attached from somewhere else to an email, so if only the photograph is saved, it might have a different date on it. All sorts of stuff about photographs that is not relevant to communication between Adam and Kayla, unless the state wants to say we have photographs that are beyond the time period, then it's a different argument.
All right, thank you.
Your Honor, I'm not going to go into addressing the different points about the case law. We stand on the cases that are submitted when you truly read them. I'm not going to go back through those and correct everything that's just been said a moment ago. The only thing I am going to say, Your Honor, is that we're rejecting any sort of implication that there's some sort of hidden material here with regards to what's on that phone. When you ask the question of whether the content of that phone has something outside of the scope, Attorney Smith stated that there's material here that she can't get into, material here that they have some material exists outside of the phone. That went into discovery back on March 17th. Defense counsel's office downloaded that back on March 30th. So if there's an implication there that the state
She's
has
not,
somehow hidden the information.
she's shaking her head. No, there's no implication about
My
that.
technical thing
Okay.
where I had to ask Mr. Gorecki,
All
not
right.
that it's not there.
Okay,
All right.
I
As
didn't,
long as
I
that's
didn't
not
take
the
it that way.
implication.
I did not take it that way.
In that case, Your Honor, we don't have anything else particularly on this. We rest on the pleadings.
Okay.
Pardon me, Your Honor, just one second. We don't have anything else on this motion, Your Honor.
Okay, and on the issue of the motion to sever, is everybody comfortable resting on the pleadings?
I think we each had a couple minutes, but we're comfortable resting on the pleadings.
Okay. Should, for some reason, you feel the need, as you go home tonight, to say, I really need my 15 minutes on that, file something with the court, I'll get you in, we can do 15 minutes on that if we need to. Otherwise, I'm going to take all of this under advisement. It's going to be some time. We do have, so we have a final pretrial on October 27th. As I think you all know, I'm not seeing a standard dispo form here, which maybe wasn't done. But 15 days prior to the final pretrial, I require motions to eliminate. Not 5 days, 15 days.
You
In
had
this
it in
case, what?
You
Okay.
did have it in there.
Yes.
So, I just want to be clear about that. Let me also just say, given the extensive nature of some of the litigation that we've had so far, it makes me, and given that there are a number of cases and a number of issues, to the extent you can file motions to eliminate early, please, please, please do. The court's docket is very full, and so finding time to get people in, if we need hearings, making sure that the court feels it has enough time to rule on them, I appreciate. So when you can, if you know something is coming, the sooner you file it, the court appreciates that, okay? All right, thank you.